Good morning, everybody, and welcome. I'm Riccardo Masucci, Global Director of Privacy Policy at Intel. We are going to start the panel now, although we are still waiting for one of the speakers that is coming. Regretfully, I have to inform you that one of the speakers, Effie Vaiena, will not be able to join us today because actually the snow prevented her from being here as her flight was cancelled earlier today. But the snow won't stop this panel to discuss about AI. It's all but an AI winter, I would say. There's great interest. And I have this wonderful group of people and experts that will help us discussing how to reconcile the need for access and move data to develop artificial intelligence with the need for protections for individuals and privacy safeguards. So with no undue delay, I would like to ask Gwenda Legrand from CNIL to walk us through the focus areas that data protection authorities over the past few years, and especially CNIL, were engaged on with regards to artificial intelligence. Thank you.
Thank you, Riccardo. Hello, everyone. So I'm Gwenda Legrand. I work for the CNIL, which is the French Data Protection Authority, and I'm the Director of Technology and Innovation at CNIL. CNIL published a report on AI and ethics of algorithms more or less a year ago, and this report gives an overview of the main ethical issues that are raised by AI, with the aim of increasing collective awareness on this issue. The report is actually the outcome of a public debate that was held in France. It involved more or less 3,000 people, 45 debates and events, and we gathered a summary of the output of the report, of the debate in the report. The debate was also held at the Privacy Commissioners Conference last year. So why did we decide to investigate this topic at the CNIL? Because AI has the potential to bring massive changes, and it builds on major changes that happen today in technology, changes in scale of computing power, massification of data, and also improvements in machine learning algorithms. Algorithms become more and more powerful and efficient, and as a consequence, they carry a major fear, which is that their underlying logic remains opaque and quite unintelligible to people. So this debate identified a couple of stakes related to AI. I'm going to list only 3 of them because we have limited time today on the panel. The first one is human autonomy versus machine autonomy. AI and algorithms allow the increasing delegation of tasks, of reasonings, of decisions to machine, and those tasks become more and more critical today. Humans tend to consider that AIs are neutral and that they cannot fail, but this carries a risk of disempowerment and the risk of disempowerment of the decision makers if you delegate the decisions to machines without understanding what the machines are doing. I will list an example, which is, for instance, the MIT Moral Machine, which you may know. It gives a number of scenarios. You know, you're in a self-driving car, there's one person in the car and one person crossing the street, and there's different scenarios, and there's a problem with the brakes, and you need to kill someone, basically. So do you kill the person in the car, or do you kill the person crossing the street? And then the scenario changes a little bit, because the person crossing the street is, for instance, an elderly person, then it's a baby, then it's 2 people in the car, then the person crossing the street crosses the street at the red light, and you're being asked all the time to decide who you should kill and who should stay alive. So it's a bit absurd in terms of scenario, because of course self-driving cars are not supposed to kill people, but it shows you that you need to think about how you want the algorithms and the AIs to behave, and this is essential. So you still need to have human decisions, and decision makers need to take responsibilities with respect to algorithms. The second point is the bias related to the biases, discrimination, and quality of the training data. Of course, there's possible side effects of the data. There's different types of AIs. We don't have time to go into this. But basically, you can either put rules and say, if you want to recognize a cat, you have to say, a cat has 4 legs, is less than 20 kilos, has a mustache, and so on and so forth. And then when you recognize a picture, you will see if it's a cat or not. And if it's not recognized as a cat, then you will change the rules. The other system is learning. So you show pictures to people, and they will say, this is a cat, this is not a cat, this is a cat, this is not a cat. And then when the algorithm decides, it makes a statistic decision saying this is very likely to be a cat, or it's unlikely to be a cat. And of course, the quality of the training data is essential. There's been massive failures of AI in the past that were related to bad training of the AIs. Think about this case that happened a couple of years ago when there was people with black skin who were recognized as being gorillas simply because the algorithm had been trained only with people with white skin, probably. So there's sometimes mistakes, big mistakes that are done by algorithms that humans would not have done, so you need to be careful with this. The last stake is related to algorithmic fragmentation, or in other words, personalization versus collective benefits. With the massification of data, the IoT, things like that, you have this possibility to individualize the risks. In the environment of insurance companies, we've seen pay-as-you-drive systems a couple of years ago. They've appeared, and the idea is that you pay only for your risk. So if you don't drive a lot, you don't pay much. If you drive a lot, you pay more. And the idea is, of course, if you drive on Saturday evenings at 4 a.m., you're more likely to have a car crash than if you just drive to go to work on a highway in the morning. And you pay depending on this. It seems quite interesting, and many people want to have this. However, this questions the very model of insurance companies today, which is based on the mutualization of the risk. So to what extent is this acceptable, and does it carry a risk of discrimination, which is that an insurance company will not accept you if you don't show adequate behavior or if your risk is too high? So based on this analysis, we've identified 2 founding principles for AI and 2 sub-principles. The founding principles are loyalty and continued attention. Loyalty or fairness means that the algorithm's criteria must not be completely at odds with certain key collective interests. It should be fair towards the users, and the users not only as consumers, but also as citizens. The second principle is a principle of continued attention and vigilance. When you're using those algorithms, they can be extremely useful, but you need to constantly question the way that they're working. You need to constantly be able to question whether or not the decision that is being made is correct. And then there's 2 sub-principles that are derived. The first one is intelligibility or responsibility. It implies some kind of auditability of the AIs. You need to understand and to be able to demonstrate that the algorithms are actually doing what they're meant to do. And the last point is human intervention, which is enshrined also in GDPR. Algorithms and machines can be extremely useful, but you should not take the human out of the picture, and you have the right to help humans to help decisions with AI, to make decisions with AI, but you should not delegate completely the responsibility to the AI and algorithms. So based on these principles, some of which are already enshrined in GDPR, and I think Carolina will talk about this, we believe that we can have responsible, ethical AIs that serve the collective benefit.
Thanks a lot, and it's amazing. It took us just 8 minutes to mention the GDPR, so I think that we are obliged to pass the mic to Carolina. And I have a pretty broad question, saying, is the EU shaping a regulatory legislative framework that is fostering innovation and artificial intelligence in particular?
Well, we are in the process now of verifying and checking whether additional legislation would be necessary. But let me take you a step back. So after the introduction of Gwendal and this mentioning of different aspects of the artificial intelligence, I think it's it's very clear that artificial intelligence poses really unprecedented questions which tackle or address enforcement of several fundamental rights. And from our point of view, from the Commission point of view, all these fundamental rights needs to be considered together. The GDPR, which took just 8 minutes to be mentioned, is addressing only one aspect, namely the aspect of protection of processing of personal data. But artificial intelligence, and here Wendell touched upon these issues already, affects also freedom of expression and non-discrimination. Now, before I will embark on the GDPR and other initiatives the Commission has and a high-level expert group and this process of thinking and verification of what could be needed in the European Union, I would like to underline that artificial intelligence is not one technology, and it's a catch-all term for different technologies which function in very different ways and different contexts. Well, because what we already have is a legislation concerning the protection of processing of personal data, so the GDPR. This is a very comprehensive legislation. It protects, it tackles processing of personal data across the board from public administration and private stakeholders. And of course, addresses also issues of artificial intelligence, which are coming within the GDPR into the box of automated decision-making process. And here are coming all the questions and all this, the way the GDPR, General Data Protection Regulations, deals with issues concerning automated decision-making process. But the GDPR also provides for, as you know, for transparency, risk-based assessments, data protection impact assessment, if necessary. Also, always when artificial intelligence is concerned and where this deployment of artificial intelligence meets the conditions for, I just mentioned, data protection impact assessment, or triggers the necessity to have one. In general, the GDPR provides for a prohibition of automated decision-making process. This is how we interpret Article 22, and with certain exceptions. But I would not like here now to embark on the explanation of what Article 22 is about. We have a very informative guidelines from European Data Protection Board. It's already a change from the 20th of May, but well, a slip of the tongue. And also from the board guidelines on transparency, which clarify what the data subject, what a citizen needs to be informed about, needs to know, and to which extent it needs to be explained, the logic lying behind any decisions which can, in the sense of Article 22 of the GDPR, namely this decision, automated decision, which can have an impact equal to the legal one, the one of the decision in the legal sense, or similarly significantly affecting the data subject. Well, but your question, Ricardo, was a little bit more about where we are and what we are doing now. So here, probably the most important part now is what we are doing within the high-level expert group, which is assessing the maybe further need to regulate in the EU on artificial intelligence. What everybody is very much aware of, that as much as the GDPR is technologically neutral, any possible regulation, should one be necessary in the area of artificial intelligence, must be flexible enough to promote, on the one hand, innovation, and on the other hand, high levels of protection and safety. And here the GDPR already provides for this flexibility, this adjustment of obligations depending on the intrusiveness of the undergoing processing of personal data. So we are now in the process of assessing whether national and the EU safety and liability frameworks are fit for its purpose in the light of the new challenges which artificial intelligence is bringing. We will publish by mid-2019, so mid this year, a report on potential gaps and orientations for safety and liability frameworks for artificial intelligence. Now, what is the high-level expert group doing? It worked on the guidelines, which were published in December 2019, which are now under the consultation process, which was extended until Friday. So you are just on time to still provide your comments on the guidelines. The member states and the Commission, and the member states and the high-level expert group met in January and were discussing already the input from the guidelines and in which direction they should be then further developed. And the comments which are coming so far, and on what member states were insisting very much, is that these guidelines should be more practically oriented and more usable. And some the comments coming so far are alleging that there should be a difference or different treatment between public administration using artificial intelligence and private sector using artificial intelligence. Well, the high-level expert group met also without the member states and discussed the aim of the guidelines, their audience, and tried to assess how this final version of the guidelines should look like, although obviously it cannot be done until the whole consultation process is finished and we have received all the comments. Now, I can tell you that the discussion within this expert group was a very vivid one. It's a very broadly constrained expert group. So there are experts on artificial intelligence, civil society, representative, scientists, as well as industry. It's a very broadly conceived expert group. And the discussions there are very, vivid and the different opinions and different ways of seeing the usefulness and the dangers artificial intelligence can bring, where they have different views which are being expressed and different ponderance as to the advantages and disadvantages. So I think this is where we are. Coming back to what Gwendolyn said and coming back on some of the elements he mentioned, this element of errors of which artificial intelligence, I understand, Ricardo, I should finish, so I'm heading towards the end. So what we now, the Commission and not the high-level expert group, which will feed into the reflection of the Commission what should be and how should we develop and roll out the regulation or framing of the use of artificial intelligence in Europe, what within the Commission, what we are doing is precisely reflecting a little bit more of how to frame and how to work with the errors while during the process of machine learning, and which errors could be acceptable and with which errors we have to be very careful. So all of this to underline again that it is not clear that the Commission so far is not clear about whether a regulation is needed or other means should be deployed and used out there in order to ensure safe and constructive development of artificial intelligence, all this with the right balance between innovation and high level of protection of privacy and personal data.
Thanks a lot for the very comprehensive overview. We have the privilege of having on this panel Justice Sri Krishna, chair of the committee of experts that advised and is advising the government of India for drafting a new piece of legislation. If you haven't read it, I encourage everybody to read the white paper they published a year ago, because it's probably the most comprehensive compendium of privacy issues and current debates. So I would like, Justice, if you could walk us through some of the highlights of this white paper and which are actually the policy recommendations that apply to access and use of data, which is the topic of this panel. Thank you.
Thanks, Ricardo. First of all, let me say that we in the committee did not like the word data subject, because I was born a British subject and I am a citizen of a democratic country, so I hate the word subject. So we tweaked the whole thing and said, I am the data principal. My data is taken by somebody who works on a fiduciary relationship. So the person who takes is a data fiduciary. So the conceptual difference is quite apparent. Now, let me take up the first, as the first topic that was being discussed by Carolina. See, every citizen whose data is taken has been considered the right to have the data maintained by a data fiduciary in correct form, and the right to interrogate the data fiduciary as to whether it has been maintained correctly and whether it has been maintained updated version of that. Now, there is one difficulty that arises when you talk of artificial intelligence. Now, artificial intelligence is algorithm-based. And all algorithms, whoever understands mathematics will tell you, is probability-driven. Now, because till yesterday I have done something, it is probable that tomorrow I will do the same thing. But there is a wide gap between human nature and probability. Probability is overall good on a very large policy issue. But for a human being who has to deal with it, it doesn't help. For example, Gwendal mentioned a number of instances. I also remember having read on the internet that they found out probably a single black lady of this particular age would be very poor and would require government assistance. Now, what happens to all those black Hollywood actresses? They are billionaires in their own right, and they don't fall within the probability parameters. Now, probably one may say an Indian should live up to 55 years today, although originally it was 21 years. Now, I'm 25 years past that, and I'm still alive. So are you going to treat me as a dead person for the purpose of the algorithm? This is where human intervention becomes absolutely necessary. So therefore, the committee recommended, and the draft bill also says, that if a decision has been taken of the data principle on the basis of an algorithm, the algorithm should be made available, subject, of course, to the rights of copyright that are available, the IPR rights that are available in the country. Because he must know what is it that you took into consideration for arriving at the policy decision. This is one of the fundamental principles that we have advocated. And, of course, as I said, the bill is still in the anvil. Now, I learned that yesterday, I don't know how far it is true because I've been sitting here in Brussels since yesterday, that the bill is likely to be introduced in the current session of the, what we should normally call the lame duck session of the parliament. But I have a gut feeling that it won't be possible to debate all the nuances of the bill in the short budget session, because passing an interim budget would be, and the final budget would really be their headache now. With the elections looming up sometime in May, general elections coming up in May, I don't think anybody would have the stomach to debate this. All that could have probably is it would be again shifted to a standing committee, parliamentary standing committee for greater discussion. And maybe it will come back in the next session of the parliament, which will be there in May. Now, some of the fundamental concepts we have introduced, apart from changing the conceptualization of the data principle and the data fiduciary, is breach, concept of processing, concept of equal liability if all processors who manage to have the data handed over from hand to hand. And then things like data centralization, which is vital from the point of view of the country. And finally, we have a sort of a different parameter with which we have to work. Namely, thanks to the Supreme Court judgment, the recent judgment, data privacy has been held, actually right to privacy has been declared to be a fundamental right, which is inviolable under the Constitution. So any law that is made has to fit within the constitutional parameters. So that is the whole thing on which the committee had to make its report. The report has been submitted. It has some novel features, some features adapted, mutatis mutandis from the GDPR, some features picked up from the South African law. And let's see how it works. It's a heady cocktail. Let's see how it works out, really.
Thank you very much. And from one country that is trying to build its legislation, we are going to another country where there's a very lively debate around the possibility of having a federal privacy law. Intel has proposed its own version of a privacy bill in the US, and this is open for consultation on our website. But there is also another organization, the Center for Democracy and Technology, that has put forward its own proposal. And so I would really like Michelle to tell us more about this, and also how did you factor in AI while drafting this proposal?
Sure, thank you. I will say we have such a different model than the EU that it's almost like comparing apples and oranges. And so I will say during our debate this year in the US, we are proceeding from the understanding that, first of all, it will have to be a consumer-facing bill. It is not going to include government access and processing of information. This is just something that we have always kept separate in the United States. And it's interesting because we recognize the government has more of an interest, right? It has a greater protective function, but also that it needs much stricter oversight because of the authorities it has. So that will be put aside, and we will not be dealing with that in this process. But dealing with the consumer side, we are very likely to do what everyone keeps calling as a gap filler. Several decades ago, we did already try to regulate health information, financial data, students' information, and a couple of other very targeted areas. And so the goal this year is to try to cover everything else, right, which is now the overwhelming majority of data. And we found that, one, people did want a tech-neutral law and a platform-neutral law. So there would be a single theory of the case to govern all of the data. And it actually would be incredibly important in the United States with the First Amendment that there wasn't a differentiation of treatment on what the platform was or who was speaking. And so this actually raised the bar and made it more difficult for us, I think, when we decided we actually couldn't tease out different actors in the system for different treatment. We decided to talk more about processes and outcomes. We did not mention technology in very many places, or if we did, it was more illustrative. It was not because we felt a very specific technology merited different treatment in and of itself. So, for example, we borrowed from a lot of concepts here in GDPR. For example, access, correction, deletion, and portability, right? This is actually now considered in the US almost a given, and that it would be in any law. It has been incredibly helpful for us to be able to point to the EU to say this is already up and running in a number of US companies, right? And we have to extend the same types of rights, even if they're not exactly the same in the US. And that has actually been endorsed by most of the companies who now have the #1 goal of interoperability, right? By acting first, the EU set the stage, and in many ways, we're kind of locked into that system and how we're debating the law in the US. I will say for us, AI and other advanced technologies represent a threat of discrimination in a way that is one of the top concerns for us here in the US. And so we do, for example, direct the government to have a dedicated process to evaluate and make binding regulations that would deter the use of these sorts of technologies that would likely lead to illegal discrimination. And this is part of the problem with the US not updating its laws, and this is actually becoming harder and harder. So we have a huge amount of ground to make up, and so we have asked them to make special attention to this area. It is already illegal and has been for many, many decades in the US to discriminate in housing, employment, education, and other targeted areas, but it's not clear that our laws are relevant in 2019, right? If an advertisement can exist for a half a second for a single person, then disappear forever, how are we able to enforce the laws that are even already on the books? So for us, this is one of the most important areas because it is a way that you can speed up discrimination, you know, exacerbate existing disparities, and we hope that is something that will become a priority in our law. I would say we tried to leave most models in place, and I think this is maybe something unique to the Center for Democracy and Technology. So we did not head-on take something like advertising or product development, which is where every conversation went back to, right? Every time we tried to write a limitation, those were the two major concerns. And so I think what we will find is we need to have a much deeper conversation in the US. Starting from scratch has been both a burden and a blessing, right? And so we are very far behind on fleshing out the details, and our decision makers don't have the same amount of information. If you look back, we've had very few congressional hearings, and the lack of action has led not only to states, but even cities. We now have cities that are trying to write their own data privacy and protection laws. It's going to be so fractured, it's going to be just simply unmanageable. So I think we are going to go as far and as fast as we can this year. I think there is still disagreement about whether 2019 or this congressional session, we work on 2-year cycles, is going to be the time, but we are going to see what we can do this year.
Thank you. So we traveled around the world between Europe, India, the US. I have a question to all panelists now that is related to a topic that is probably quite central in the overall discussion around development of artificial intelligence, which is the possibility to move data across borders. We know that to develop algorithms we need reliable data sets, and the opportunity of having this data moved from different countries could help developing some algorithms. I'm sorry that Effie Vallena could not be here today because we had long discussions while preparing this panel, and she was saying how the health sector, for instance, in the healthcare sector, it is so crucial to have access to very different data sets, very diverse data sets, because in this way we can not just in a way limit the biases, but also make sure that these algorithms are more effective, more accurate, and so the outcome of these algorithms can apply to different types of population and can be effective also for ethnic minorities. So again, cross-border data flows, free flow of data versus data localization. I know that all of you have something to say, and I'm probably looking first of Justice Sri Krishna, who certainly has a clear view on that. Thanks.
Yeah, view is clear, but I do not know how much my view is going to weigh with Parliament. It all depends on what Parliament ultimately does. And Parliament is subject to all kinds of lobbying, you know that. Anyway, as far as when I talk of the committee's views, not personal views. See, as far as making available, let's start with data localization. Data localization was strongly advocated by the committee and has been thoroughly reflected in the draft bill that has been circulated. Now, what is the advantage of data localization? I start by asking a question and say, why should the personal data of critical personnel, say take the President of India, the Prime Minister, or the Chief Justice of India, or the heads of the Army, Air Force, and Navy, why should it be located in a far-off country like, say, Timbuktu? The disadvantage is when it is to be accessed, now every time I have to go through a process of law, which is something like your MLAT in USA. And we all know how inefficient MLAT works. It takes at least 12 months to 24 months to get any particular answer to a query that is raised, which has to go through a whole process in the originating country, and it has to go through a whole process in US before it is finally answered. Now, this is something like the extradition laws. Whenever there is a jurisdictional conflict, each state tends to assert its own sovereignty and subjects it to its own laws. But I don't see any reason why the data that is generated in India should be maintained in some other country where I have to take some other person's consent before I can access it. Now, this is one of the reasons. The other reason is, as you rightly said, Ricardo, data is the raw material for all artificial intelligence research. Now, if all the raw data is maintained somewhere else, now how am I going to make sure that the AI research goes on at a rapid speed, which it must in these circumstances in our own country? Therefore, the committee and the bill make it a point to say 3 types of cross-border flows. A, critical data, which you need not maintain anywhere else, must be maintained only in India. B, data which you can maintain anywhere else, but provided a live copy is maintained in India, where ease of accessibility is guaranteed. C, certain other types of data which can flow across the border. Like, for example, the health data. As long as it is anonymized, I don't think there is a difficulty, because health data under conditions of anonymity is very useful for research in health programs, for research in elimination of diseases and things like that. Now, these are the 3 prongs that have been postulated in the draft bill on the basis of the recommendations. Now, there is a lot of debate on this. Now, the only answer that is given is, hey, what guarantee is there that the data that is localized and kept will be available for artificial intelligence research? What's so difficult about it? I have something within my jurisdiction. I can always pass a law and say, make it available to me on conditions of anonymity. But I can't do this if it is in US or in South Africa. Number 2, now with regard to critical data, there is no need to transfer it at all. It remains only here. I was mentioning it in the earlier panel, that the Reserve Bank of India, which is the regulator of all financial transactions and payment systems, has already jumped the gun. Even before the law became operative, they used their powers under the Banking Regulation Act, issued a directive and said, all financial data with regard to payments must be maintained within the country. Now, whether that is good or not, the only argument that is made, that was made by all the multinational corporations was, hey, this will increase the cost of doing business. Well, if it does, it does. It doesn't matter. You want to do business, you're interested in doing business in the country, add it to your cost of business. And lo and behold, what happened to Visa, what happened to MasterCard, what happened to what other Amex? They all agreed. Initially, in fact, the Reserve Bank gave them a deadline. They said, if you don't do this by this date, I'm going to stop your operations in India. So Visa was the first one to jump the gun and said, okay, we will do it, sir, no problem. And now the others have said, we will do it, but give us some more time. So ultimately, if it is necessary and it has to be done, it will be done. There is no difficulty at all. Because today, India is such a big market. Everybody wants a slice of that. Now, you want a slice of that, you got to pay for it. You'll get only what you pay for. So this is the attitude that we have taken. And let's see how Parliament runs through the bill. And I'm sure if the Parliament agrees with the recommendations made, it will be in the near future maybe. But of course, we have given a long period of gestation because people have to tweak their own softwares, tweak their own business models. Probably a 2-year and odd model time has been given, at the end of which, as I said, the writing is on the wall, but I can't predict how far the wall is from where I am right now. That's my attitude.
Thank you.
Yeah, maybe just a few words from the European side, but GDPR already is a regulation on the protection of personal data and free flow of personal data within the EU. That's the first thing. So you have one law with the same rules that apply everywhere in Europe. And as long as the data stays in the EU, you have the same safeguards, so you can transfer the data in the EU area. And on top, there's articles on the transfers of personal data outside the EU. It's Article 46, so the principle is you shouldn't do it. And if you have the appropriate safeguards, which may include binding corporate rules, adequacy decisions, standard contractual clauses, and so on and so forth, then you can transfer data. And of course, what we've said, there's other articles also that are relevant in that context in GDPR, because, for instance, the security article, privacy by design, because when you decide to locate your data elsewhere or have access to data that is elsewhere, you need to take into account security. There's an obligation in GDPR to secure the personal data processing, and it's an obligation of a reinforced means obligation. So you need to have the adequate means, and you're close to you have to ensure that you will have a good result and that you have actually secured the data correctly. And of course, when you do this, you do your risk analysis, and if it's bad to locate the data outside for security reasons, then location can be one of the elements that has to be taken into account in the risk analysis. So very quickly, I think this is, of course, taken into account in GDPR. GDPR takes into account the principle that within the EU, there is adequate protection, and that the protection of personal data that is enshrined in the GDPR follows the data when the data travels outside of the EU zone, and this is done with the transfer articles that you see in GDPR.
Well, if I may complement, from the Commission point of view, the best way really to foster international, not only EU intern, as you mentioned, Gwendol, international free data flows is through acceleration and deepening of the ongoing global convergence process. And we see that actually a very similar way of addressing data protection and privacy concern are being now deployed throughout the world, beginning with India. We see three main elements in this convergence, namely one, horizontal legislation and not sectoral one. We see a move towards enforceable citizens' rights. And we see also setting up and a very strong push for independent data protection authorities. And this converges throughout the world. Let's not forget that the European Union just established with Japan the biggest area of free data flows on the basis of high level of protection. Yeah? So these three elements are very visible in the convergence in addressing the data protection and privacy concerns throughout the world. We all are facing the same problems while protecting our democracies and while protecting our citizens. So I would like just one more element, Convention 108, which starts to be membership in this Convention 108, which was a very European thing, starts to be much more universal, which is, from our point of view, also an element showing precisely this global convergence as far as ways of addressing data protection concerns are concerned. And indeed, the best way to ensure international free data flows is this convergence and deepening of the ongoing harmonization process throughout the world. Thank you.
Can I say one more thing? I'll take it up from where Carolina said. The way I envision is, you started off with principle of territorial sovereignty. That gave rise to all kinds of conflicts. Then we had environmental sovereignty. Then we have sovereignty over the territorial waters. Now today, look at what has happened. If I want to send goods, say from Mumbai to Los Angeles, you have the Warsaw Convention for carriage of goods. You have the Intermodal Transport Convention. So everybody knows that the laws may be different. The local laws in Los Angeles will not be the same as Mumbai or anywhere, Calcutta or Chennai in India. But then you have worked out a system by which, without treading on each other's toes, business can carry on. This is precisely the idea. I do envision that a day will come when the data sovereignty will also be the subject matter of an international convention. In fact, I would advocate and say there should be an international body to adjudicate a dispute like this. For example, what happens if there is a dispute? The WTO, the GATT, all these are intended for trade disputes. And there is not much difference in conceptualization between trade dispute and data sovereignty dispute. So ultimately, you could have bilateral investment treaty arbitration. So you could have bilateral data protection arbitration. And the Permanent Court of in Hague will probably see more and more adjudicatory solutions to these kind of problems. But that is in the future.
Well, sorry, I know we need to move on, but one final thing. I think there are different motivations, though, for data localization, right? The judge mentioned law enforcement access to information. We saw it mentioned a lot after the Snowden revelations and U.S. access to data here that goes through the U.S. And but I think there's also some protectionism, right? People want to develop a technology industry in their own country, or frankly, there are some countries that have very low standards for civil liberties and civil rights, and they want to make sure they can access data on their own citizens, including political or religious minorities, journalists, students, dissidents. And so not all data localization is the same, right? That's the problem. And I think, sadly, some of the consumer interests, whether it's access to good data, right, and good products or good privacy roles, are going to be subsumed to some of these international political dimensions that are leading to the localization in the first place.
Thank you. And so in this context of convergence, an international convergence, which are, and I ask this to all panelists in no specific order, which are the initiatives that both governments and private organizations should undertake, very specific initiatives in order to improve the current situation, both on the access and use of data, but on the other hand also on protecting individuals. Do you have something in mind, or is this something that you would like to highlight in this context?
Thanks for the question. This relates for me to the way that we implement the fundamental principles for AI that we were mentioning earlier. Practical implementations of this can go through training, of course, of all the stakeholders, so including developers, companies, and citizens who need to be made more aware of how this is working, so they understand, when they consent to the processing of the data, what is actually going on. The rights need to be correctly enshrined in the systems. This is essential, and it's related also to the training of the developers, so that we organize some kind of mediation between the law, the systems, and the users through the interfaces. So the way the interfaces are being designed is essential. The role of the designers, probably in the way systems interact with people, needs to be better understood, better taken into account by the regulation. In this respect, at the CNIL, we published 2 weeks ago a report on the design of privacy and the role that the interfaces play in influencing the consent of individuals to the processing of their data, and the different techniques that are being used by designers to present choices to the users and influence or perhaps sometimes manipulate users. So it's essential to take this into account, to understand it, and to build the desirable frictions between users and interfaces so that they actually understand what they're doing. Not just have a very simple interface with no information, with the less is more principle, because this is not fitted to all the privacy requirements. Auditability is also essential. You need to have more work on how to verify that the algorithms are actually doing what they're meant to do. So this means research in auditability, and then it means competence in auditability to be able to have some third-party checks to give some kind of assurance on what the systems are doing. And of course encourage, there's a lot of researchers here, encourage research on AI to have an ethical AI, an ethical access to data. I think this is essential. And the last practical thing is this ethical dimension in companies needs to be strengthened to make sure that this is taken. We have the DPO, we need to have some kind of similar function on ethics that is pushed and developed in companies.
And I would say one of the first things we need to deal with is making the data that's already public usable, because it's not a lot of times in the US. And I was struck by, I was living and working in Florida, and a story came out about a specific division of a police department that was over 90% of the time stopping African Americans, over 90% of the time doing stop and frisks, and over 90% of the time having to let them go and never charging them. And it was, as they called it, a crime suppression tactic to basically scare people, right, and intimidate people. And the only way it was discovered was a reporter got a tip. And Florida has some of the best public records laws in the United States, except when you went to the criminal justice records, you could only search by a single signifier. So he pulled the names of these police officers in the unit and then had tens of thousands individual documents that he could no further process. So he basically went to the journalism school and had students by hand process the data to come up with statistics and figure out what was going on there. And it was such a good example of that should not happen, right? Here's something that's so high stakes, criminal justice data, it's already public and it's just in an unusable form. So that's one of the first things, but I think we are also still struggling with what should be public in the first place. I know our government mentioned just last month that there are parts of the census that will not be made public for the first time in 170 years because they are worried about re-identification and that the processes they've been using to date are just no longer sufficient. So I'm not sure what it's going to look like the next time they put out the 10-year census out of the US, but we have to find better solutions to protect the data if we want to keep releasing it.
Well, I think I understood your question about, so what should be there so that that convergence work? This is how I understood your question, Rika. So, I think I would fall back, but maybe I misunderstood something. Or you want to, what has been done? What we provided for all the tools for transfers, yeah? So that for different tools of transfers, among them, of course, adequacy decisions, which is not requiring a copy-paste of the European legislation, but which requires that the Commission assesses whether the third country gives our European data adequate level of protection, so that, as Gwendal mentioned, the protection we give to our European data with the EU travels with this data wherever it goes. We attach this convergence developments, and what for us it's very important is what I mentioned before, US is an adequate country without an horizontal omnibus legislation, but nevertheless we see a development in this direction, enforceable data subject rights and independent supervisory authority. And so we work with this elements. The convergence doesn't mean copy-paste of what we have here, but requires assurance of the outcome of the equally high level of protection as we have within the EU. Now, how it's achieved by individual stakeholders, what Gwendal was more talking about, this is, of course, the quality of data used, auditability of the results, which for the purposes of this panel, artificial intelligence produces, is very important, but within the EU, we have ensured it via Article 22, where there and Article 15. So the necessity to be able to explain the logic involved in automated decision-making process, so that whoever uses this algorithm must be able to explain in an understandable to a normal citizen words what was it, what this algorithm was used for, which data was used for it, and what is the outcome of it, how does it affect this person. And the transparency that it was deployed. So, well, I think this, and then leaving it up to the companies on the basis of accountability principle and this data protection by design, by default, to deploy and to invent different methods of providing the information and providing the explanation, and also ensuring that a human will be involved in and will check the results of such a decision.
Much of what Carolina just mentioned has been envisaged in the data bill, data protection bill which has been circulated. Now, check on the artificial intelligence, the algorithms used, and your ability to interlocute the persons who have used the algorithms so that he can find out that if there is any hidden bias in that. We have also said that there should be an overarching data protection authority to whom this kind of a dispute can be escalated. So if you're not satisfied with the answer given by a public authority or a private company as to what is the algorithm that has been used, and you suspect that there is a hidden bias, you can escalate it to an independent adjudicator who will go into it with the help of experts and say, yes, this is biased or this is not biased. That is one way of looking at it. And then the data protection authority is envisaged as the overarching authority which will monitor the implementation of the act throughout the country. Also carry on with education of people, because basically citizens must be made aware of their own rights as to data protection. That will be done by them. They will hold seminars in different centers, data centers, educate them on the kind of requirements that are there to have good data centers, which will not result in breaches that we have been seeing in the newspapers. Now, and also, they should be able to carry on a dialogue with people in Europe or in South America or in the USA on what are these concepts of adequacies that are necessary. Now, can I transfer my data to X country without fear of breach? What are the X countries? What kind of fundamental rights do the citizens in the country have as against my own fundamental rights guaranteed under the Constitution? This is one of the reasons. Basically, I would say, whole of data, the philosophy that we adopted was, the whole of this law is like a triangle. At the top is the citizen who has the right, fundamental right, or you call it the human right here. Then at one apex is the state which needs to monitor it for obviously security reasons, for obviously criminal justice reasons. And the other is the trade and commerce, which needs to care up itself because it's going to be affected by it. So ultimately, between these three forces, there will be a resultant found which will be satisfactory for everybody. Now, obviously, if I'm a shoe manufacturer, I can't say I'm going to manufacture only one size shoes. But the objective is that I will manufacture shoes that are comfortable. That's precisely what we have followed.
Yeah, very briefly on, so in Europe also you have, this possibility to file a complaint with the DPA, and this is, in France we receive 11,000 complaints, individual complaints, and now we also have a kind of system with collective complaints. So if we count all the individuals who filed complaints at the CNIL, we're probably around 40,000 people who came to the CNIL last year. But to go back to transfers very quickly, we talked about the instruments that are enshrined in GDPR, but the data protection authorities themselves, both in Article 29 and EDPB, have been doing also a lot of work on some of the transfer tools, and this was not mentioned. So there was work to update the BCR referentials for controllers and for processors. The application forms and the procedures were also updated when GDPR came into application. And there's an ongoing dialogue also with other regions of the world that have transfer tools in specific regions. But the difficulty when doing this is that we have high standards in Europe with rules that are applicable here and that are not necessarily with the same safeguards in other areas. So just to give a couple of examples, there are about things that are very important here in the EU and that we don't necessarily find in other transfer tools. Our law applies to publicly available information. It does not allow notice to be given after the collection of personal data. It applies to sensitive data. There is a requirement to erase the data or make it anonymous once the retention period has expired. So this concept of retention period is essential here in Europe, and we don't necessarily find this in the other frameworks. There's a right to action that we talked about that is given to the individuals, and we have very specific rules also on onwards transfers, because it's essential to understand that there's a kind of bubble of protection around the data that needs to travel together with the data. These principles are essential and they're taken into account whenever there's discussions on transfer tools and compatibility or interoperability of different transfer tools across the world at the global level.
Okay, thank you. I would like to ask the organizers, because I see on the screen that we have still 16 minutes, but it's probably less. I don't know if I can get any feedback, but probably it's time. I still have a couple of questions, but I would like to actually open the floor for questions from the audience, if any. And so, yeah, there is a mic there, so there is a gentleman coming, and if you want to do the second one, thank you.
Yes, thank you. I'm Patrick Pennings, the head of the Information Society Department of the Council of Europe. Thank you, and also Carolina, for mentioning Convention 108. And I think, Justice, you would have an interest in looking more closely in Convention 108, and I hope that we will be able to exchange a little bit on that. I just wanted to say, well, yes, last year the buzzword was fake news. This year the buzzword is artificial intelligence. What we try to do in the Council, first of all, is to look at what is that fake news and dismember it and look at it more closely. We need to do the same thing with artificial intelligence. Are we speaking about self-learning algorithms? Are we talking about machine learning? We have to be more specific. I think it's a buzzword, and we need to, this global term, we need to make it more specific. And obviously, thank you for also updating us on what the European Commission is doing and European Union is doing with the high-level group on artificial intelligence. There's a lot of processing in that, I would say. I think there is already a number of very specific consequences, and the Council of Europe, not only covering the 28 but 47 member states, is already looking into what are the consequences on the democratic processes, on elections, on biomedicine, on predictive justice. And we just have issued ethical guidelines on predictive justice. Automated processes and manipulative functions of automated processes, criminal justice aspects, equality aspects, children's rights aspects. So we really need to look into that more specifically. Council of Europe is going beyond an ethical framework. We want to be launching a reflection within the Council of Europe on a framework convention. We're doing that. We did that on data protection almost 40 years ago when we elaborated Convention 108. This was a benchmark and has been a benchmark for a very long time. It's been modernized, and the modernization process is well underway. We're having already 25 signatories as of yesterday or the day before yesterday, so that's an enormous progress. The Convention 108 worldwide has now 53 member states, participant states, and this is increasing. Quite a number are in the pipeline. And when we're talking about a global instrument, Justice, I think it's important that we think of Convention 108, Convention 108 Plus as a global instrument. I think the major difference there between a bilateral adequacy agreement between the European Union and a third country is that within Convention 108, countries are party to the convention. And that does not only enhance bilateral relations between the European Union and third countries, but also enhances cooperation between those third countries. And that is an essential feature. By the way, Russia is one of the countries that had already signed up to Convention 108, and it was the first one to sign, one of the first ones to sign the modernized convention. I think in the Framework Convention we need to set out a number of beacons. I think it's also important that we look at what do we understand by data and data collection, because quite honestly, the idea of being able to determine data collection in geographical locations is completely outmoded. I think data, the specificity of data collection right now is that it's mobile and that it travels around the world, and it is not limited to any specific geographic location. And we have to be able to look at it also from that perspective. Thank you.
Thanks a lot, Patrick. Please, madam, if you want to make your question, and then I will ask the panelists to react.
Yeah, I will make it quick. Thank you very much for all of your presentations. My name is Helene Jansen. I'm working as a researcher at Cambridge University at the Computer Science and Technology Department. Well, I was wondering, in terms of localization, what do you think, or what do the panelists think about hyper-localization, where instead of the processing taking place at a central level, the process will take place at a decentral level, so where personal information systems are spread amongst consumers and users, so that they can, control, they can capture, they can have the analytics on their own machine, they can see what is going on in the machine. And the promises are like, there's more transparency, people can see what is going on, and they know what they are sharing afterwards, after the analytics. So I'm just curious to know whether you want to share a couple of thoughts about this. Thanks.
Thank you. Any reaction on Convention 108 and the last question on hybrid localization, if I understood it correctly? Thanks.
It seems like that could only be useful for very advanced users, and I would say one of the things we have come down to is that our primary goal is shifting the burden for this data processing to be more fair back onto companies. And so I don't know if that is solved by putting it on people's devices. And we want to be honest about what control looks like in a world where there are dozens of devices in a home, thousands of apps, who knows how many advertisers touching the data, and how realistic it is to control and make meaningful decisions, when we should just have the people who are processing the data treat it more fairly.
I'll comment briefly also on this architecture choice, basically, of the computing. In general, GDPR is about control of individuals over their personal data. So if the data stays on the devices, it's more likely to be under the control of the individuals. This is a general philosophy. Well, depending, of course, how the access is done on the device and so on and so forth. But this is something that is implemented in many different areas by data protection authorities when they examine different systems. One example is, for instance, when we look at biometrics, whenever the biometrics stays on a device that is under the control of the individuals, it will in general be considered to be more privacy friendly by design than if your biometric data is sent on a server and you don't know who is going to process the data. So it's a general architecture principle related to privacy by design, and of course it has to be implemented with the adequate safeguards and also with the adequate interfaces to decide what you're sharing and with whom you're sharing the data, but it can contribute to more control over your data for sure.
Indeed, I fully agree, but let's not forget that this control, it all needs to be a meaningful control. It needs So going back to the step of transparency and information, it needs to be an information which is an understandable one, understandable for the person who is being informed. And the proof that the person understood what is going on rests with the data controller on the basis of the principle of accountability. So whatever is being done needs to be done, obviously, in accordance with the GDPR, and the control cannot be one just on the face of it, that people have, that at the end of the day, our citizens do not understand what is going on with their devices. Well, so just...
Any further comment? Are there other questions from the audience? Otherwise, I would like to I would like to ask you to join me in thanking our panelists for this very interesting discussion with a round of applause. And thank you.